welcome to the Trademark Like a Boss show. I am Radiance Harris, also known as the Trademark Goddess, and I'm excited to have Angela Grayson with me today. If you are watching live, be sure to say hello in the comments, drop where you're from, let us know you're here. If you watch the replay, drop the hashtag replay so that we know that you tuned in. So welcome to the show, Angela.
I'm excited to be here. You guys should know that we were fangirling on each other right before we started. Radiance and I go back a long way, and I'm always excited when you allow me to be a part of your world. So thank you for having me.
Oh, thank you, Angela. It's a pleasure. Yes, Angela and I go back a few years. We met actually at a conference. We were on a panel together discussing intellectual property. I think at the time I was discussing like trademark or hashtag trademark. She was discussing patents, and it's just been a match made in heaven ever since. When people reach out to me about, getting patents and all of that, I always refer them to Angela because I don't, specialize in patents at all. Trademarks and copyright is all I do. But Angela is amazing and phenomenal at all things patents and inventions. So
thank you.
Welcome, and please, so introduce yourself, let our viewers know like who you are, what you do, who you serve.
Absolutely. So again, thank you for having me. I'm Angela Grayson. I am the principal member and founder of a technology law boutique called Precipice IP. We specialize in helping science and technology startups protect their products, designs, and data. I am someone who started the business after about, 15 or so years of being in corporate America and working at the Patent and Trademark Office and working in large companies. So I took a lot of that big business mentality in terms of an approach to intellectual property to the small business. Our practice is very much around products, and we were having a conversation prior to the start, what is the difference between invention and a product? And I think businesses, large companies really handle that distinction a little bit better than small businesses. So I'm excited to be here.
Yeah. So share with us, so what made you leave corporate America? You said you were in-house like 15 years. So what made you take the jump from corporate America to starting Precipice IP?
Yeah, so that's a super, super great question. I have worked at some great places, started out at the U.S. Patent and Trademark Office, worked at a couple of pharmaceutical companies, worked at specialty chemical companies. So my background is actually a chemist. So I'm a lawyer that's a chemist. It's also a patent attorney. So I've always been around kind of science and technology, large kind of institutions. But I've just always had an entrepreneurial itch, really, that needed to be scratched. And the other reason, frankly, is just, as a Black woman, I just needed to find a safer space to work. I just needed a place where I could foster a more inclusive environment and provide that to the people that I work with. I've often said, I don't know what the future will hold, but I definitely will never go back in building again. So that, TMI perhaps, but for me, and every entrepreneur kind of has their own story about freedom. And that's one of the things that starting my own business has provided me. It's just the freedom to live sort of philosophically, do the work that I want to do, help the people that I want to help. And it's just given me a lot of choice. So those are the things that I needed at the time when I started Precipice.
I love that. I totally am feeling you on that freedom. Like that's one of the main things I think inspires a lot of entrepreneurs to take that leap of faith is like freedom, whether it's freedom in time or freedom in money, whatever your focus is, I can feel you on that. So I want to go back a little bit on something you talked about, the difference, I guess, between product development and patents or inventions. Like, explain more about that, because I have no idea like what the difference is.
Yeah, so when you're in large companies, their business units around, what a company's core capabilities are. And within that business units, folks develop products to be sold to customers. when you're a small business, people have an invention and they seek out someone to help them protect the idea or the concept. But at the end of the day, what you're trying to sell people is a product. You're trying to sell people a service. You can't really sell people a concept, and nobody cares about your idea.
Right.
So whenever I tell people, I definitely try and steer people whenever I do consultations with them. And I never accept person as a client before I've had at least one conversation with them, because it's important that if you are going to pursue, let's say, an invention, an inventive idea, you need to understand, hey, it's going to take more than a patent to make you successful. You're going to have to approach this in terms of product development. Where is the market? Who is the market? Is the market big enough? Do you know if this is a good product market fit? All of those questions, as a patent attorney, I don't have to ask, but I do want to ask, because I don't want people throwing away money on a lawyer when they don't have enough skill or enough understanding to understand that, hey, if you want to recoup your costs, you've got to shift your mindset. Because this whole idea of, building a better mousetrap and they will come is actually not true.
Right.
You've got to be more disciplined in terms of getting that product or service to people who would want it.
So then how does someone determine whether their product or invention is eligible for patent protection? Like where would someone start?
That can be a complicated question on so many different levels. I would love to say that the patent process is easy but it's really very complicated.
Right.
And I know that I probably sound like I'm so important, but it really is complex. And, I spend a lot of time making sure that I'm updated on the rules and on the laws and all the case law. And it's still complex for me.
Yeah.
And so I think that it's always a good idea to talk to someone. Some lawyers will charge you a fee for a consultation, some might not. If they do charge you for a fee, pay the fee, because what you don't want to do is go down a path thinking that your idea is patentable when it's not. Your idea may be innovative, but whether something is patentable is actually a legal question.
Right. So at what time should someone explore? Should they explore patentability at the product development stage, after the product actually developed? At what time do you sort of explore this question?
That is such a great question. I think the sooner the better. If you have an idea, the first thing I would do is hop on our friend Google or however you do your searching to see if that product exists. Maybe do a search on Amazon just to see if the product exists. If you feel comfortable that the product doesn't exist, then maybe you should hop on like Google Patents and just do a quick keyword search to see, okay, the product may not be sold, but maybe there's a patent out there, or maybe there's a patent application out there. Because all three of those things, if they occur before you file your patent application, will keep you from getting a patent. So there is a little bit of self-serve that I encourage people to do. And after doing kind of a quick product search, after doing a quick patent search, again, nothing crazy. If you feel like there's some white space out there for you to operate in, then maybe you can talk to a patent attorney and say, look, this is what I'm thinking about. I always encourage people to do some sort of search before they actually file their patent application, because the office is going to do their search.
Right.
And you don't want to be surprised, right? You want to make sure that you know what's coming down the road.
Yeah. So in your experience, your
early
career experience, it should be sooner rather than later.
Absolutely. Okay. Absolutely.
Yeah. And that's the same with trademarks. I always tell people sooner rather than later.
That's right.
Preferably before you launch. But so in your experience, what would you say are the top 3 patent myths that you've come across, like over and over, the top ones that you come across?
The one that's probably more irksome is design patents are meaningless. And design patents are incredibly attractive, they're strong. And the difference between a design patent and a utility patent is that a design patent will protect the way something looks, and a utility patent protects the way something works. So, people like to say, well, it's so easy to get around design patents. Well, actually, that's not true. It's a likelihood of confusion, which you know very well as a trademark lawyer, which is not the same thing as a straight up copy.
Right.
And I think there's a lot of latitude in that. So, and by the way, when a customer encounters your product, they're going to look at it from the outside, right? They're not going to necessarily look at it from the functionality always.
Right.
So that to me is one big thing. Another thing is, you can't protect software innovations, and that's not really true, but you do need to go a little bit beyond what you might expect. The thing that I think is more troubling is people may have a software concept, but they may not be a technical founder. And I'm going to let that sit there for a second. You may have a software concept, but you don't really know how to code. You don't really know how to bring it to life on an app. So you've got to go get someone else to do that. Maybe that's someone onshore, maybe that's offshore. But if you're not a technical founder, it's going to be very difficult for you to provide the level of information that is needed in order to get a software patent or a software related patent. So that's kind of a thing. That's a big deal. And many times, people have great business ideas, but collaboration sometimes blow up among co-founders. The technical founder leaves. You've got the non-technical founder with the business, and they really don't have the ability to move forward with patent prosecution and giving the attorney everything that they need. So that's kind of a big deal. And let's see what's another myth. Maybe people don't understand how long it takes. It actually takes a super long time.
Right.
Pursuing registered intellectual property rights can be a really long-term proposition.
Yeah.
And it's not a one and done. Your relationship with your intellectual property attorney is very much a long-term thing. Right. So, you're doing this search in the beginning, you're filing, it's going to take a year or more for the application to be picked up by the examiner. You get engaged in the prosecution. That could take another 6 months to a year on the patent side, maybe 2 years. So at the end of the day, it can be very expensive. It can be also kind of a long-term thing. And when it comes to patents, once your patent is registered for utility patents, you have to pay maintenance fees, just like on the trademark side on some level. So there's more long-term after that. So the one thing I tell people and everybody, well, how long does it take? A long time. I'm not good at that marketing because it takes a long time.
I hear. I mean, the trademark process takes. I mean, it's a lot shorter than the patent process, but it's taken right now about 14 months. But there are some applications that I filed, like I would say, end of 2020 that are still pending.
And it's taken longer, right? Since we first kind of started this, it was a year you'd have your registration if you were lucky. A year they will pick it up to examine it is kind of where we at right now.
Right. So let's continue with some trademark myths. I know you do some trademark work as well. So like what about so one that I always get is like the fact that registering my business name with the Secretary of State or registering domain names is the same as registering a trademark, which is false.
I roll.
Not the same. Another common one that I get, like people think that like trademark rights are international. So they're like, if I get the US federal trademark, that means I'm protected worldwide. False.
Exactly. Right. Everybody wants things to be simple, one fee, one-stop shop.
Right.
But that's unfortunately, and I really, it's this sort of anti-marketing, but the intellectual property realm can be very complex. It can be very straightforward, as well. But, I think for me, I've seen fewer of those instances. I could count on one hand really how many registrations have issued with no office actions. For me, very few. And that is, and also the same on the patent side. So you're dealing with a complex system, and you want to know what really breaks my heart. And I hope the USPTO is watching this. When small businesses have to constantly deal with office action after office action after office action. People don't understand how debilitating that is for a small business. Number one, they're already intimidated by the process. Number two, to maybe get a rejection that is kind of stretching it. is a lot, and they want to give up.
Yeah.
And that truly breaks my heart as a small business owner. And I'm like, no, don't give up. You're too
Yeah.
close. But and so that, so the complexity of it all, and sometimes people feel very overwhelmed by the process.
Yeah.
It's a little heartbreaking
But I
sometimes.
know that on the trademark side, I mean, there's like a 70% refusal rate. So like more times than not, you're going to get some kind of initial refusal. I mean, is it that
Absolutely.
high with on the patent side as well?
I don't know if it's 70%. It's probably more like 90.
Really?
You're going to get an office action, and an office action is the same thing as it used to be when I started doing design applications. There were very few, but you're gonna get an office action no matter what you do,
Wow.
which means more legal fees. But
Yeah,
yeah.
absolutely. Absolutely. Well, okay. So, what would you say is your number one piece of business advice to someone who is a business owner who might have intellectual property of their own? What would be your
I
business?
would say do the very best you can to be an educated consumer of these services. I've always said that from the beginning. Be an educated buyer of legal services to the extent that you can. Before you enter into the process, before you have a conversation with a Radiance or an Angela, hey, do your own little quick research. Come
Yeah.
to the conversation with a little bit of kind of understanding the nomenclature, just a hair, so that the conversations you're having with your lawyer can be more productive. And just understanding to the extent that you can, kind of what you're walking into, both the benefit and kind of the opportunity, or kind of the challenges. So just be a knowledgeable buyer of all this stuff. And I think if you start there, it's a good foundation.
I love that. That's true. That's true. A lot of people just kind of like, all right, so tell me what I need to know. And it's like,
Right. Tell me what I need to do. I'm like, you tell me.
yeah.
This is your
Or they
product.
don't want to know anything. They're like, let me just hire. Like, I don't want to figure it out. Like here, and I'm honestly, I've done that for quite. Like do that with taxes and like bookkeeping.
Yeah.
There are a lot of things I just don't want to figure out. But you're right. It is important to have some kind of knowledge about the process. Not to say you're going to do it, but just know kind of what to expect or what you can at least do on your end.
Exactly.
Sure. Yeah.
So you can ask good questions at the very least. That's kind of the way I feel the same way about taxes. But it's like, okay, let me read this. Let me see what this section is, so that I can at least ask my tax preparer some good questions, right? So
no, I hear you. So as we wrap up, please let our viewers know where they can find you, get in contact with you, find out more about your services.
yes, so please reach out to us and follow us if you're curious about kind of how to utilize product development and protecting your intellectual property. We are on most streams of social at Precipice is kind of our handle. So you can find us on LinkedIn and Instagram and Facebook for sure. You can also please visit our website, www.precipiceip.com. Yes, it's a mouthful to say. Strong brand, hard to talk, hard to say, but we're out there. Very few law firms are Precipice, so that I'm feeling pretty good about my trademark strategy there.
Should come up at the top of the Google search.
Okay. Oh, and the other thing is I do Meetup Mondays, free consultations. They're only 15 minutes, but if you're curious, feel free to schedule some time at the website. And, I'm happy to answer any and all questions about your business, short of giving you legal advice, of course.
Yes. Well, thank you so much for joining me today, Angela. It was fun.
The pleasure was absolutely all mine. Anytime I get to fangirl on my favorite trademark lawyer, I will not pass up on that.
The feeling is mutual. You're my patent attorney, favorite person, favorite IP, everything. So thank you so much. I appreciate you. I know you are busy, so thank you for joining me.
Thank you.
And thank you to you all for joining us today on the Trademark Like a Boss show. Until next time, I love you. Take care. Bye.